Institute of Law, Nirma University. It gives me immense pleasure to welcome you all to one of the sessions for the International Teaching Month, which is organized by Institute of Law, Nirma University. So I, on behalf of Institute of Law, welcome all of you. Thank you, Professor Ayer, for taking out time and joining the session. Without any further delay, I would just like to give a brief introduction of Professor Ayer, and then I think we are ready to go for the session. So Dr. Ayer is a barrister and academic based in Northern Ireland, and he is attached to the School of Law at Ulster University. And he was also, he's also been a part of the World Bank project, where he had designed a program on continuing legal education for the Kenyan bar. Today, his session is on how important are professional ethics for lawyers. And considering the fact that all of us are from the stream of law, and all of us are professionals either in terms of litigation or in academia, learning about the ethics and also understanding its importance and the conduct which every professional or a legal professional or a student is supposed to build in them is something which is very important. And today we have all gathered here to hear it from Professor Ayer on the importance of professional ethics for lawyers, for students, and for all the legal professionals and everybody who is in the profession of academia as well as law. So over to you, sir. I wouldn't be taking much time, and I would now like you to discuss with all of us on the topic. Thank you so much and welcome again, sir.
Thank you very much, Gunjan. And can I reciprocate by saying that it is a delight to be able to speak to students of Nirma University. I've had the good fortune of being associated with your university now for a few years, and it is something that gives me a lot of satisfaction. I'm pleased also to see that your director, Madhuri Parekh, is with us on this occasion, and I want to extend my greetings to her as well, formally. What I intend to do today is to talk about the topic which Gunjan has already referred to, which is how important are professional ethics for lawyers. And I suppose I can start by saying that there are no prizes for guessing the answer to the question in that title. And that answer is a very emphatic, extremely important. But the reality of the world in which we live is that ethics are not always given the importance they deserve. Now, there are huge pressures on lawyers to act amorally, if not immorally. But I would argue that lawyers need to resist such pressures if they are to be true professionals. Now, the scenario concerning professional ethics in the law varies very significantly between countries. In the many jurisdictions in which I've had the good fortune of working over the last 20 to 30 years, I have noticed that some countries are better than others. And there are many reasons for the variations, which I don't have the time to go into, but it is a matter of some regret that we do not yet have a consistently high level of professional ethics when it comes to the legal profession. Now, if it is any consolation, I can say that the legal profession is not the only profession where the level of ethics is not uniformly high. Because if you look, for example, at the data that comes out for other professions, including the medical profession, there also you'll see that there is a lot of unethical practice, which is rather unfortunate. I'm not talking about any particular country. I'm just talking about the overall situation. And so we need to be mindful of that background when we discuss professional ethics. Let us not forget that lawyers belong to a privileged class. And there is an expectation on the part of society that lawyers will behave with due responsibility to give something in return for the privilege that they enjoy. Not always is that sentiment in the minds of lawyers, which is a pity, because there is absolutely no doubt, particularly in poor countries, that lawyers are given an enormous amount of respect. In that sense, they're very privileged. Now, getting into the topic itself, I suppose it would be pertinent to ask, what are we talking about when we talk about ethics? In other words, what is the nature of ethics? Again, I'm not going to spend too much time on this, but just to lay the ground for what I'm going to talk about subsequently, I thought I'll make a few remarks. So when we're talking about ethics, we are talking about moral philosophy. And of course, morality is something that is both variable and controversial. Very often, morality is seen to have roots in various religions or faiths. But I would argue that it is possible to see morality as being independent of religious beliefs, which means that even someone who does not have any religious belief can and should act morally without recourse to anything that he or she might learn from religion. And ethics are important for collective reputation of the profession. Ethics are also important for the credibility of the profession. In particular, the public is unlikely to have confidence in lawyers if lawyers do not behave ethically. And of course, there's another dimension to this, and that is that the rule of law, about which we talk so much and which is such a prized virtue in almost all decent societies, is based on justice, fairness, and equity. Now, if lawyers behave unethically, then all those principles cannot be given effect to. And this in turn will also result in people losing faith in the legal justice system. So there's another reason why ethics becomes so important. Don't forget also that the practice of law is what is called a reserved occupation. Now that means that no one other than those who have actually completed the legal studies and also any vocational training to become lawyers will be allowed to practice law. And in those circumstances, there is an even more compelling reason for lawyers to behave ethically. Because if they don't, there are no alternatives to designated lawyers, which means that if lawyers fail society, then there's really no hope in society for the pursuit of justice. Now, you are probably familiar with some of the main principles that are often discussed when it comes to legal ethics. But I'll just give you a very quick run through of those principles, and you're very welcome to raise other principles that may strike you as relevant or important. My purpose in talking for the first about 30 minutes or so is essentially to give you some pointers, and I would very much like interactivity, which is a point I keep making in all my lectures. So I sincerely hope that you will all contribute to the discussion that will follow when I stop speaking. So in terms of the major principles that are encompassed within legal professional ethics, there are a few, such as the independence, the honesty, the integrity of lawyers. Another way of putting it would be to say that we should not look at lawyers simply as hired guns shooting on behalf of their clients. That would be a very wrong way of looking at lawyers. There is, of course, the sanctity of the lawyer and client relationship, under which many duties are owed by the lawyer to his or her client. And these duties include, at the very least, things like client care, avoidance of conflict of interest, respecting confidentiality in dealings, and also being very careful when it comes to handling client money. These are all obvious, but they are not always appreciated to the extent that they should. Then there is the other thorny issue of remuneration for lawyers. How reasonable should a lawyer's fee be? And this is a point on which I have much to say in the Indian context, which I won't say now, but if you're interested, do ask me about it during the Q&A, and I'll be happy to elaborate. Now, in addition to a lawyer's duties to his or her client, there are also duties that a lawyer has towards the court. As you know, a lawyer is usually referred to as an officer of the court, and he has to discharge many obligations to the court, all of which require a high degree of ethical conduct. On the other side of the equation is the matter of competence. In other words, a lawyer should work to the highest possible degree of competence, in other words, to the best of his ability. And part of that, of course, comes through legal education. It comes through occasional training. But there's much more to it. For example, I would say that it is a lawyer's ethical duty, even if it's not prescribed in law, to engage in continuing legal education throughout his or her professional life. Now, unfortunately, this is not given the importance that it deserves in many countries. Gunjan referred in her introduction to a project I did for the Kenyan bar, which was about continuing legal education. So what was involved there was a scheme under which all practicing lawyers in Kenya are required to undergo or undertake continuing legal education for a fixed number of hours per year. Now, I can see a possible criticism of such a scheme, and that is to say, what guarantee is there that even if you compel a lawyer to do some reading for a certain number of hours or to attend seminars or workshops, that he'll actually absorb the essence of what he reads or participates in? That is a valid criticism. I don't deny that. You could sort of, look at it in a very colloquial way, encapsulated in that old saying, you can take a horse to the water, but you cannot make it drink. True, that can happen. But I think having CLE programs is at least one step forward in the process of enhancing a lawyer's continuing competence. And of course, a lawyer has duties which go beyond the client and the court. A lawyer also has a duty, I would say, to society in general. So it would be incumbent upon a lawyer, not legally, but morally, to, for example, undertake pro bono work as far as possible. And that is something which nowadays is being spoken about more than it used to be in the past. Of course, in the past as well, lawyers used to undertake pro bono work, except that that entire area of activity was not given as much visibility or prominence as it is being given now. But even there, a lawyer has to be very conscientious, and he should not treat pro bono work as simply something that he's doing by way of window dressing. In other words, he has to put his mind fully into what he's doing, even though he's not getting paid for that kind of work. When you talk about legal ethics, there is also frequently reference to the position concerning advertising. In other words, can a lawyer advertise his or her legal services? The practice varies from country to country. There are many jurisdictions, for example, the United States of America, where advertising is allowed and advertising is common. So you'll find a lot of lawyers bringing out fairly garish advertisements, asking people to avail of their services. Now, those who don't like this say that that is so demeaning to the profession, because it is almost as if you're making a lawyer like a businessman or a trader. But of course, the Americans would not agree, and they have their reasons, because one of the arguments used is you increase the public's pool of information about lawyers, and they're therefore able to choose from a wider pool. That would be one of the arguments used. So this is a topic on which there can be a wide range of views. I'll simply leave it there and let you think a little bit about it. If you want to discuss it again later on, I'll be happy to pick up the point. I've mentioned a lawyer's general duty towards society, and nowadays a lot of emphasis is being put on human rights In other words, to what extent should a lawyer promote human rights in the course of his work? To some extent, that is also related to pro bono activities, but I mentioned it just in passing. On a very practical level, the next question that arises is, where do legal professional ethics come from? And I would say there are many sources. So you'd first of all have the professional regulatory bodies, like the bar councils, many of which enjoy statutory backing. You can also have ethics coming from voluntary professional associations. An example would be a High Court Bar Association or a District Court Bar Association, of which there are many, I know, in India. These are voluntary. You don't have to be a member of any of those associations if you don't want to. But there are some advantages of being a member of such bodies. I would argue also that professional ethics come from peer pressure, that is, pressure that emanates from your colleagues. And usually you would think that such pressure would be positive, and the more of it, the better. But really, in a sense, the most important source of professional ethics is a person's individual conscience. In other words, you have to have certain habits of the heart which will make you behave ethically. To my mind, that is the most important source of professional ethics. In addition, if you want to take a slightly longer view, you could think about the historical traditions and practices that have taken root in any society, particularly in countries like England. There's a very strong historical tradition concerning barristers, and that also has a huge influence on legal professional ethics. Again, if you want to know more about some of these things, you are very welcome to ask me when we have our Q&A. And finally, I would say that there's also the influence of international best practices when it comes to legal professional ethics, because you can see and learn from the best practices in other countries, and if those practices are adaptable in your own country, then you should adopt them. Now, because I don't have the time to go into all the aspects of legal professional ethics, I thought I'll just deal with one or two. So I want to talk a little bit about, for example, a conflict of interest, because that is something which happens a lot of the time in the life of a lawyer. A lawyer faces many conflicts of interest, and he or she is put in a dilemma about how to deal with them. So I thought I'll just spend a few minutes talking about that. An obvious question that arises is, should a lawyer act for both sides in a property sale transaction? Now, in some countries that is allowed, but in many countries it is not allowed. Why? Because there might be conflicts of interest. In this particular situation, there's no guarantee that there'll be a conflict of interest, but there can be conflicts of interest. But really also there is the other aspect when a lawyer acts for both sides, and that is, what does he do to keep information that is received from one party confidential as against the other party? So confidentiality of client information becomes quite relevant in this particular scenario. Now, if you're talking about a law firm, of which I know there are many in India, is it possible for, or is it ethical for one of the partners in a law firm to act for one side in a dispute, or even in a property transaction, and for another partner to act for another party? This is not at all easy to resolve, but one way in which I think in some countries they resolve this dilemma is by saying that a lawyer can act for more than one party in a transaction or a dispute, as long as he or she takes the consent of all the parties. Now, whether that's a satisfactory solution, I cannot say. I'll leave that a question open. Again, we can discuss it if you like. What about a situation where a lawyer is asked to take up a case for a party who is facing a dispute with another party for whom the lawyer has acted previously in a completely different transaction? Now, this is also very tricky. In some circumstances, there is no problem. But in certain other circumstances, there is a problem because, again, the lawyer may have been privy to confidential information that he has received from the other party. And so there is some uneasiness often in such situations. More commonly, you may come across a situation where you are a lawyer and you are asked by someone to take up their case against another party who happens to be a friend of yours. Not necessarily someone for whom you've acted in the past, but he just happens to be a friend of yours. Should you take up this case? Again, it's not an easy question to resolve, because in a way, if you fail to get the results that your client is expecting, the client may think that you may have been influenced by your friendship with the opposite party. So again, it is a tricky situation. And of course, equally commonly, you may come across a situation where you are a lawyer and somebody comes up to you asking for your services, and you discover that the party on the other side is connected to someone close to you, not you directly, but someone close to you. So, for example, your spouse. Should you take up the case? Again, it depends, I would say, on the circumstances. There's no single answer to that question either. Yet another very important dilemma that a lawyer faces sometimes, or a question that arises a lot of the time, is how far can a lawyer go in defending a client? Of course, I told you at the beginning that a lawyer should act to his best ability to defend a client, but can he forsake ethical principles in defending his client? The answer is almost definitely no. And so the fundamental answer, the basic answer to a question like how far can a lawyer go in defending a client will be only up to a point. He cannot, under any circumstances, break the law in defending a client. Very important. And this happens particularly in criminal cases, because there are certain red lines that a lawyer should not cross. Nor can he ask his client to break the law. That also would be unacceptable, unethical. Now, a stark example of a dilemma that a lawyer might sometimes face is you have a client coming to you, and I'm talking about criminal cases here, a client comes to you and says, I have committed a murder and I want you to defend me. Now, this is very, very difficult for a lawyer because normally the client is presumed innocent until he is proven guilty. That's a fundamental principle of the law. What if the client himself or herself says, I've committed a murder? Should the lawyer defend such a person? It is not easy at all. In normal circumstances, at least in countries like the UK, the lawyer would decline such a brief. Again, as I said, this is a very major ethical dilemma. I've already mentioned that a lawyer should not encourage a client to break the law, which also includes a situation where a lawyer tutors his client to do something that has the effect of breaking the law. Now, sometimes you have a client coming to you and asking you hypothetical questions, which may result in the client breaking the law. Now, this is slightly more, this is slightly different from the scenarios that I've just mentioned, because you don't really know beforehand why the client is asking those questions and that he's going to break the law. So I would say that in such situations, you need to ask the client some searching questions before you're able to answer his or her question in turn. Can a lawyer point out loopholes in the law to a client? The answer has to be, generally speaking, yes, because the law does allow for defenses which rest on loopholes in the law. But again, this is a matter of degree, because if in the process justice is defeated, then I think there will be very serious ethical issues arising. We can also think about one other type of dilemma, and it is to be found in a situation like this. Suppose you are a lawyer who is appearing for somebody who's accused of serious crime, and the client has made it known to you that he or she is planning to flee the jurisdiction. In other words, to get out of the country before the case is heard. And you have a hearing before a court in which an application is made by the other side to, for example, confiscate the passport of this client. And what you do is filibuster, that is, prolong the proceedings to such a degree that in the meantime, your client can leave the country. Is that acceptable? My answer would be definitely not. So you can see the range of dilemmas, ethical dilemmas that a lawyer faces. But of course, in addition to all this, there is the overriding duty that every professional has, and lawyers are no exception, to make sure that they act with courtesy. They also are good at timekeeping. They pay attention to detail. This is something which applies to all professions, not just lawyers, but it is important in lawyers. And this should become a habit. This is not something that you can learn from textbooks. You really have to keep in mind these principles at all times. There can sometimes be moral dilemmas which arise from a possible clash between law and justice. In other words, the law may allow you to get away with something, but in the process, justice gets defeated. Now, this is a very, very difficult thing for a lawyer to be able to resolve. And I would say ultimately depends on an individual's conscience. Now, during a lawyer's professional life, there are also certain things which may appear very mundane, but which are important. For example, if you're a lawyer who appears in court should you not dress appropriately, and to the extent that your professional status requires you to. I'm bringing this up because, as you must have heard or seen, there have been many instances in the recent past, I would say in the last, say, about 18 months in India, where, because of online hearings, you find lawyers behaving disgracefully. There are lawyers who address the court sitting in motor vehicles, sometimes motor vehicles that are moving. There was, I think, one occasion where a lawyer was actually addressing the court wearing a vest, what in India is called a banyan. Completely unacceptable. Another senior lawyer I heard was addressing the court while on the hookah. Now, quite clearly, these are very unacceptable. And to a large extent, it is a mindset that makes people behave like this, and that mindset has to change. Can a lawyer exploit his clients or his juniors? Definitely not. And again, this is as much an ethical issue as it is a legal one. And so there's an overlap here between law and ethics. But if you're minded to behave ethically, then quite frankly, we don't even have to consider the legal position, because you're bound to say no in certain situations where it would also have legal implications. And another common problem nowadays is, can a lawyer take undue advantage of his position vis-a-vis his juniors? Now, I'm sure you must have heard of a few cases where senior advocates are accused of sexually harassing their juniors. This is, of course, as a result of them having power over their juniors. Again, unethical, completely unethical. I've already mentioned the matter of fees. Now, there again, it's not simply that a lawyer should not be extortionate in the fee he charges, but also that he must make sure that he keeps his part of the bargain. In other words, he turns up in court fully prepared to argue the case or to do other things that he is required to do under the contract. That again doesn't happen all the time in certain jurisdictions, and maybe we can talk about it later. How are professional ethics enforced? I would say that in most jurisdictions, you have codes of conduct, and codes of conduct are documents which contain elaborate rules of behavior. And if a lawyer breaches a code of conduct, then there can be disciplinary action taken against the lawyer. But of course, a code is only as effective as its enforcement. And in many countries, there are good codes, but the enforcement is quite lax. And a lot of the time, codes of ethics become mere window dressing. And that, again, gives the profession a bad name in that particular country. Another way of sanctioning lawyers who behave badly is, of course, through the law, and that is by bringing civil claims for negligence or breach of trust, etc. And in exceptional circumstances, it is possible for a lawyer to be prosecuted for criminal offenses. So if, for example, a lawyer has stolen clients' money, then he or she could be subject to the rigors of the criminal law. But really, in a sense, I would say that more than all these codes and laws is motivation and courage to act ethically, which cannot, as I said, be learned through textbooks. Now, I think I'm coming very close to the end of my time, so I'll wrap up very quickly. Just to tell you that there are quite a few cases of unethical conduct in India, and I would point out to you one or two which became quite famous, and maybe you want to look up the judgments in these cases. These cases went to the courts. So, for example, there was a case involving a former president of the, former chairman of the Bar Council of India. Just imagine the highest professional regulatory body, the chairman of it, a man called V.C. Mishra. Now, he was convicted of contempt of court, and the judgment in that case is worth reading. More recently, there was a case involving a senior lawyer called R.K. Anand, who was accused and then convicted of suborning witnesses. It's quite a serious thing for a lawyer to do. And again, you can find reference to that case on the internet. So please do take the time to read up such materials. Also, you have, if you're interested in this topic, various other sources of information, including the codes of conduct in various jurisdictions. There's also the International Bar Association's principles on conduct for the legal profession. In the UK, you have the Solicitors Regulation Authority handbook, which gives a lot of guidance. Likewise, you have the American Bar Association's model rules for professional conduct, in addition, of course, to many codes of conduct on a stateswide basis in the United States. So quite a lot of that, which I would say would be worth reading on. And I think at this point, because I've really taken up all the time that was allocated to me, I will stop and invite questions and comments. Thank you very much.
Thank you so much, Professor Ayer. It was a really great session, and even I am teaching this subject in the current semester, professional ethics, and I seem to have got so many different points and so many new aspects to look into and teach the student from those perspective. And we have most of the students who are from the second semester who are studying professional ethics. So the very first question that one of the students has is, what is the difference between professional conduct and professional ethics? That is the
right. There is an overlap between the two. You can't put them in completely separate compartments. Because conduct encompasses a huge area, of which ethics is an important factor. So what it is your conduct should always be informed by ethics. In other words, how you conduct yourself has to be ethical. So in a sense, there is not much of a difficulty there. But you can also, if you want, be very technical and say conduct would be things like your competence, your training, how you actually present a case. Those things can be considered as part of conduct if you're very strict about it. Actually, it's not. And then ethical issues would be conflicts of interest and many of the other things that I highlighted. So I would say actually that the overlaps are very significant.
Thank you so much. The other question that is there is, it's about when we are defending as lawyers, when we are defending our client, and there is a limit, you were mentioning that to what extent can an advocate or a lawyer go, but say that the facts are very confusing, and they are they are not exactly in our favor, but they are illegal. So in this case, how do we define our limits?
Yeah, the starting point will be to respect the principle that every person is innocent until proven guilty. So even if you have a hunch that your client may have done something illegal, you cannot use that as the basis for jumping to a conclusion, because ultimately, whether he is guilty or not is the job of the court, not of the advocate. So you have to keep an open mind, but you cannot be completely naive. So what you have to do is, where there is a strong suspicion in your mind, strong and reasonable suspicion, this is very important, then what you have to do is, you have to ask your client some very searching questions. You cannot allow your client to simply tell you, don't worry, I've not done anything wrong. That is not good enough. But that's not good enough for another reason, because if you're going to defend your client properly, you need to have access to all the relevant information. And how will you get access to the information? Partly through documents, partly through witness statements, but more importantly, also by asking questions of the client. So if the client then either becomes evasive or says things that are not satisfactory for other reasons, then you may have an ethical dilemma, because at one point you may decide that there is something completely fishy and something really unethical in what is happening here. And you don't want to have to do anything with a case like that, in which case you will return the brief. But that is very rare. I would say, generally speaking, unless there is clear evidence that your client has done something which involves breaking the law, you should go ahead and try to defend your client to the best of your ability.
Okay, thank you. Thank you so much, sir. There's one more question pertaining to the aspect of fees and the
Yeah.
how much the advocate can charge and the ethics behind it. So, what
Yeah.
is your take on that? Do you think that, like, this must be regulated with some rule, or like, is it something that should be like, inbuilt in the advocates, or how, like, how should this be pursued?
Okay. The first thing I'll say is that I'm completely against regulation. In other words, for any outside body to say that you can only charge so much for this, that, or the other, because that will lead to all kinds of undesirable consequences. Because for a start, you will have the practice of under the table payments straight away. I can assure you, because that is human nature. If somebody says you can only charge 1,000 rupees per hour, when you know that your competence is much higher than that, and your client has a complex case which you cannot do at that kind of rate, then you're bound to adopt other means of getting your money. So I'm totally against regulation. But I am equally against lawyers behaving unreasonably and extortionately when it comes to matter of fees. And I will give you examples. It is not uncommon now, I understand, in India for some senior lawyers to charge 1 crore of rupees per appearance. And I'm not talking of exceptional circumstances. This happens, I'm told, routinely with some lawyers. Now, I cannot imagine anybody really being worth it to that extent, and there's no point in saying, but my client is willing to pay, because ultimately you have to have a conscience. Are you really putting in so much effort, intelligence, talent to justify such extortionate fees? And so it has to come from your heart, ultimately. Now, it is true that in a free society, the market will to some extent determine the rates. So one of the arguments that many Indian lawyers use when you criticize them for charging too much is, but the market allows us to do this. We are working in a free market economy. So in a free market economy, if the buyer and seller agrees on a price, then that should be respected. I have no problems with that. I'm actually a great champion of free enterprise. But the issue then is the market genuinely free, in the sense that, are there safeguards against anti-competitive practices? So if you have only a tiny number of senior lawyers who not only capture the market, but also keep out other people from entering the market, then there is no justification at all by way of that argument for extortionate fees. So I'll give you an example again from India. Indian lawyers are extremely resistant to the idea of allowing foreign lawyers to practice in India. But these same lawyers want to practice outside India. So just see the hypocrisy of it. And they have this very spurious argument which says we need reciprocity. In other words, if, for example, Indian lawyers are allowed to take up work in England, only then English lawyers would be allowed to take up work in India. Now, that is a spurious argument because the standards of both competence and ethics are so different between England and India. And unless there is some equivalence in standards, that argument just wouldn't work. Now, why don't you do this? Why don't you raise your performance high enough to be able to meet the standards in those countries where you're seeking to go and practice? That is a question which unfortunately is never answered. It is a very, very difficult area on which to have sort of prescribed solutions. As I said, ultimately, it is a matter of conscience. But you know what actually makes me even more angry is not only that many Indian lawyers charge extortionate fees, but also that they don't deliver to their clients in spite of charging such high fees. So very often, the lawyers who, not just the lawyers who charge high fees, but many lawyers generally don't even show up for hearings when they're supposed to. And part of the reason is they are overcommitted. So they accept cases in 10 different courts. How can they ever be able to attend to a particular case? So they send juniors, they send someone else. And one of the reasons why you have so many lawyers being used in cases in India, particularly at the Supreme Court level, but also in the high courts, is because the client is not sure whether a lawyer whom they want is going to turn up. So they will probably have to engage 4 senior advocates to make sure that at least one of them turns up, which is deeply unsatisfactory. So it is a very, very complex issue, but regulation from the outside is definitely not the answer.
So the next question is that you were mentioning about the pro bono work that these days the advocates have started taking up. So what is the difference, and if at all there is a difference between the pro bono work that is there in India in comparison to the other countries, and especially from where you come? So would you like to give your input on that?
Okay. In essence, there is no difference because pro bono work means that you're accepting work without expectation of a fee. That is the simplest definition of pro bono work, and that is what happens in practice. But I can tell you that at a practical level, there is at least this difference that in India, pro bono work is more informal than formal. In the UK, for example, if you're doing pro bono work, a lawyer will have to comply with certain formalities, filling out forms and making sure that the contract is properly signed with the client and all that. In India, it's more informal, which is not a bad thing because, ultimately the Indian market is like that. A lot of the clients are illiterate and they don't have the sophistication to deal with a lawyer. And in those circumstances, the lawyer says, look, don't worry, I'll take your case and argue it and I'll deliver results for you. So it works. So let me give you an example with which you may be familiar. There was, as you know, a very famous lawyer in India called Ram Jethmalani. Now, Ram Jethmalani was a controversial figure for other reasons, but he had this very interesting practice of doing a lot of cases completely free of charge. He used to say, I think that he used to do 90% of his work pro bono and 10% on a charging basis. And when people used to criticize him for taking up cases of smugglers and other criminals and then charging a huge amount of fees from them. So his answer was, and he was very honest, his answer was, yes, I do take up a lot of work from criminals, but then, and I also charge them a lot of, heavily, but you don't know how many cases I do completely free. So even if the 90% figure is not correct, the fact is he used to do a lot of, and I think much of what he did was again fairly informal. So he would not sign a contract with a client saying, I'm now doing your work pro bono, but it will be done fairly informally. And of course, he would probably deliver the results that the clients wanted.
Yeah, so thank you so much, sir. And there is one just last question that, I'd like to take from one of the students who's saying that what will be your advice for the first generation lawyers, especially in these testing times of COVID, when jobs are also uncertain and practice is also uncertain. What is your one piece of advice?
Well, I would say actually make use of the time to learn more. Now, luckily, the present generation of lawyers is able to access a lot of knowledge and information relatively free of cost, almost free of cost, through the internet in a way that previous generations did not. So I would say make use of the time by learning, because learning is what is important. And that includes not just reading books, which is certainly valuable, but also talking to other lawyers, talking to senior people, going to court, just sitting and watching proceedings. And nowadays, one of the good things that has happened is, for example, in Gujarat, the Gujarat High Court is live streaming proceedings. And even I, sitting here, sometimes watch those proceedings. And I must say, they're quite interesting as well as informative. And you can actually compare that with the live streaming from the Karnataka High Court. And quite frankly, I would say that Gujarat is far superior to Karnataka. So that's one. And of course, don't forget, you can also use your time to hone your skills by, for example, writing articles. And that will also in the long term be of great help. Give informal legal advice, which is allowed in India, but not in other countries, to poor clients. Not take up their cases, but just give them advice. And maybe accept some pro bono work if you're already a lawyer. So there are quite a few things that you can do.
All right, sir, thank you so much for such a wonderful session, especially your inputs on the concept of continuing legal education that you were talking about, which should also be something that advocates should continue. I think that is one of the very innovative and an important step that we as a country must also adopt. Thank you so much for being here with us and discussing with our students and all the participants on the topic of how relevant is professional ethics, especially in an environment where everybody around us is unethical or not very moral in their conduct. On behalf of Institute of Law, Nirma University, I once again would like to thank you so much. And I would also like to thank our Dean and Director, Professor Dr. Madhuri Parikh, who's always been very supportive for all such sessions, and also Professor Shreya, who's been who's done so much of work in deciding the sessions and the topics for the session. So I'm sure this session has been very fruitful for all the participants. And especially for me, I had a really good time, listening to you. It's been a pleasure. And thank you so much. Would like to connect with you in future as well. And thank you. Thank you so much. Thank you.
Thank you very much. And I look forward to seeing you again tomorrow and possibly some of the other students as well.
Yes,
okay?
Sure.
All the best. Bye-bye.
Thanks. Bye-bye.